Yes, good afternoon.
Very good. All right. So we're ready to proceed with this case. And just to remind you all, each side is given 20 minutes to make their argument. And if you're the appellant, you'll be given up to 5 minutes for rebuttal. I'm going to make one request that whoever makes the argument, please, the other side, please mute your mic. That way we could hear and hear you as well. And if there's any technical difficulties that may come up, let us know. I know there's a number of there's a whole bunch of phone numbers that were given earlier. Hopefully we won't get to that point, but there's always ways to go through this. And so with that, we're ready to proceed. Ms. Haverfield, you may proceed, ma'am.
Thank you. Good afternoon. May it please the court. My name is Stacey Haverfield. I represent the appellant and former husband, Paul Jacobs, in this post-judgment family law appeal. If I may, I would like to reserve 5 minutes for rebuttal.
Very good, ma'am.
Challenged in this appeal is full of errors, all of which, taken individually or taken together, require reversal. We ask that you reverse this order in total and remand only for the issue of attorney's fees and costs. The order on appeal is insufficient on its face. As we pointed out in our briefs, issues 2 and 5, the order is supposed to hold the former husband in contempt, and it does so without making the required findings per Rule 12-615-D1. The order also awards attorney's fees and costs to the former wife, and again does so without making any of the required statutory findings. The plain language of the rule and the statutes are clear. These findings are mandatory, and a read of the order on appeal is also clear. They're missing. For these reasons alone, this order should be reversed. But let's dig a little deeper. The trial court held an evidentiary hearing on the former wife's second motion for contempt and enforcement, refusing to hear the former husband's previously filed supplemental petition to modify alimony. The court did this in error. We recognize that there's no transcript of the evidentiary hearing. However, both sides worked to produce and ultimately have approved and included in the record on appeal a statement of proceedings. We don't know what the trial court said beyond that. We only know what's contained in the statement of proceedings. We do know, however, that the trial court had no authority to rule and resolve that second motion for contempt before ruling and resolving the supplemental petition to modify alimony. The material
wasn't the petition to modify alimony based on his temporary unemployment, and therefore, because it was only temporary when he was reemployed, the petition for modification was moot, and at that point his temporary unemployment was only relevant to determine whether his failure to pay was willful for the purpose of the contempt proceeding?
That's a very limited view and one that we don't share. The supplemental petition could have been modified, amended before going to hearing. There was outstanding discovery that the former husband was expecting, and until it was resolved, it was not moot. And it's important to note that the trial court at the time of the contempt hearing did not dismiss or rule as moot the petition for, or the supplemental petition, but rather just ignored it and informed the former husband and his trial counsel, we'll hear this at a later date. The supplemental petition, we think, was a viable motion, even though it contained allegations of the temporary unemployment, because it could have been modified. And again, there was outstanding discovery that was expected and could have afforded an opportunity to amend that. The court should have heard both together, but the court ignored that. Instead, the court—
Ms. Haverfield, I guess at some point your client dismissed that petition?
Yes, sir. He did. 5 months later, in February 2019, he dismissed the supplemental petition by filing a notice of voluntary dismissal.
Is that an abandonment, albeit after the contempt hearing?
Is that abandonment? Perhaps of the supplemental petition, but please keep in mind the harm continued. The contempt that was imposed upon my client still remained, and we think in part because the trial court failed to follow the law and hear both motions either simultaneously or hear the supplemental petition for modification of alimony before the contempt motion. And also please keep in mind that attorney's fees and costs were assessed against my client. So while the supplemental petition was dismissed voluntarily, we don't know the reasons why, but it was dismissed, that still does not render the trial court's actions regarding the inappropriate procedural method not a case in controversy. I mean, there was harm that followed from that, and we would like that remedied.
As I read the statement of the case that the parties put together, it strikes me that the husband had an opportunity and in fact was able to testify about his reduced or lack of income during this period of unemployment.
He was able to testify in a very, very limited fashion. And so with regard to due process, we submit that he did not receive it. So he wasn't able to testify fully as to his current financial situation. Please keep in mind that he was unemployed unexpectedly and suddenly in November 2017, filed his supplemental petition in 2018. He paid 2 months of $2,000 per his responsibility. For the next 8 months, paid somewhere between 100 or 150. So even though he had depleted his savings, was putting charges on credit cards, and was borrowing money from friends and family, he was still trying to some extent, meet his obligation, although we all recognize that that was reduced. In July 2018, he finally received employment again at $8,000 less in the state of Pennsylvania. Of course, he suffered all of the relocation expenses. And a few pay periods later, we have this hearing on the motion for contempt. The financial affidavit, when viewed closely, you can see that when he listed alimony, he listed it at $975, not the $2,000, and he was still in the hole every month. And then that financial affidavit doesn't discuss or address the loans that he had taken from friends and family. He was not allowed to testify as to these things. He was cut short. He was told that it wasn't relevant. According to I was not trial counsel, but according to the statement of proceedings, he was told, I'm just going to rely on your financial affidavit, despite the fact that you're here and willing and ready to testify. It was so bad, his trial counsel was proffering to make sure that she could create a good record. In addition, with regard to the lack of due process, he was trying to cross-examine the former wife and was prohibited from doing so. He was told that his line of questioning was not relevant as to her need and ability to pay and her relative financial position. So as far as due process, he wasn't allowed to fully testify. He wasn't allowed to fully participate, and that severely injured his ability to put on a defense which was necessary considering what would follow from this contempt motion, which was a contempt finding, arrearages, and an assessment of fees and costs. And even if the trial judge put the required findings in the order, which it didn't, and even if the supplemental petition and the motion for contempt were heard together as law dictates, which they weren't, the record evidence does not support contempt. There is not substantial competent evidence in this record to support a contempt finding against the former husband. Okay, so what are the facts here? Again, they're not in dispute. The facts are that he was gainfully employed, lost his job suddenly. 2 months into his unemployment, he was still making payments in full. Following that, he filed a supplemental petition. He continued to pay at least something until he was reemployed in July 2018. And in July 2018, he was reemployed. He increased the amount, albeit not to $2,000, but he did increase the amount to $250. And then a few months later, we have this contempt hearing. This is not an individual, and these are not the facts to support contempt. Finally, we require, and the law necessarily mandates a reversal. These are not the facts, again, to support contempt. He wasn't afforded an opportunity to fully explain what was happening, his current financial position. And finally, the court cut him short. And so it wasn't a full and fair hearing. So for those reasons, we request that you reverse the order on appeal and remand only as to attorney's fees in light of the fact that there's not enough record evidence to support any finding of contempt. Thank you.
Thank you, ma'am. All right. And if I could trouble you now to mute your mic, and then Ms. Jack, if I could have you unmute your mic, ma'am, and you may be ready to proceed with your response.
Good afternoon, Your Honors. May it please the court, I am Renee Jacques, pro se, the appellee. I'll be brief in my argument. I'm asking to affirm the trial court's order for contempt, alimony, arrearages, and attorney's fees and costs. The argument is made by the appellant that the trial court did not consider the previously filed supplemental petition to modify by the former husband, and therefore the contempt order and associated should not be affirmed. I argue that the trial court did, per the statement of judicial proceedings on page 2, evaluate through proffer by Mr. Jacobs' attorney that the singular allegation of the supplemental petition to modify, that being that Mr. Jacobs was not employed and had changed, and that he was in fact employed and had been for 3 months at the time of the hearing, and he elected to not pay his full court-ordered durational alimony when he had the ability to do so. This negated the singular allegation in the petition to modify, and therefore the trial court dismissed the reminder of counsel and proceeded with the contempt hearing and did schedule this at a later date. This was solely based on him not being employed, and at the time that this was filed, he had been gainfully employed for 3 months and unilaterally made the decision to not abide by the court order and pay the court-ordered alimony. This case was also heard and was granted in part a contempt in May of 2018, where he was found in contempt of court for non-payment when he was employed, gainfully employed at that time, where the judge ordered him to pay the rearages of the payments that were not made at that time. So this was a two-part, contempt when it came to this case, because Mr. Jacobs has a history of non-payment even prior to him losing his job in January of 2018. That's where the income withholding order comes into play, because he made the decision on his own to not pay his court-ordered alimony. So this was a case that was scheduled at a later date to be heard, and he did voluntarily dismiss this case. It doesn't state that an objection was ever offered by Mr. Jacobs' counsel. I mean, it was never objected that this case, not be heard. It was heard, and Mr. Jacobs did, testify in this case. There was no overruling to an objection that's argued by Ms. Haverfield. Further arguments by the appellate is that there was no due process, or that Mr. Jacobs was not allowed to testify in his behalf. It's not supported by the statement of the judicial proceedings that we're going by, because transcripts to this case just don't exist. References to his testimony by direct and cross-examination are evident throughout the document. By example of pages 2, 3, and 4 of the statement of judicial proceedings, document items 4, 5, 6, 7, and 8 of the appellant's direct testimony. All of these items are relating to his income history, his alimony payment history, his ability to pay, and his changing circumstances. Mr. Jacobs was examined and detailed by his counsel on direct. Cross-examination testimony and review of Mr. Jacobs' original and then current financial affidavits revealed that the financial status of Mr. Jacobs had improved since the original marital settlement agreement, and in testimony, he admitted the same. This indicated to the court his ability to pay his full durational alimony payments once reemployed, and his neglect to do so for 2 months prior to my filing a motion for contempt, which at that time, it was 3 months of non-payment. So even with Mr. Jacobs' change of circumstances, his financial health was admittedly, by his testimony, better at the time of the hearing than it was when he entered into the marital settlement agreement. This testimony also served to indicate his ability to pay for attorney's fees and costs to me at the time, and it was awarded by the trial court. As we know, there is no, court transcripts that exist, and we are going, by the judicial proceedings that the lower court signed off on. It's a reliance of the statement of judicial proceedings in this case, in the absence of the court transcripts, that the best effort by both of the parties and the court is to recollect the events. And, as I said, the trial court approved the document. The court made judgments and conclusions based on the evidence that's been presented. And we begin the process with the presumption that the trial court is correct. And with that in mind, I'm asking that you affirm the trial court orders.
Very good. Thank you, Ms. Jack. I appreciate that. If I could have you mute your mic right now. Ms. Haverfield, you have 5 minutes for your rebuttal, okay?
Thank you. Respectfully, we disagree with Ms. Jacques' rendition of the facts. Indeed, there is no transcript, but also indeed, the former husband did not have the ability to fully testify. And really, it's the fully testify that is part of the problem. He is entitled to an opportunity to participate meaningfully in that proceeding, and he was denied that all the way around, just because he testified to his payment history. So even though he was unemployed and borrowing money from friends and family, he still paid every month something. And when he was gainfully employed in July 2018, he increased that on his own without being directed or told by anybody else. He was not able to talk about the expenses or fully talk about the expenses that he had. He wasn't able to fully talk about the loans that he had taken from friends and family that were in a position that needed to be paid back. He was not allowed to testify as to any of that. He merely testified as to payment history, job loss in 2017, and then job gain in 2018. That is not a meaningful participation in this process, not when you have contempt and attorney's fees at stake. That's one. Two, he wasn't able to fully cross-examine Ms. Jacques as to her inability to pay, which sort of begs the question, frankly, how the trial court could have awarded attorney's fees. I mean, you need that analysis per 6116, and the trial court just simply did not do it. So even on issue 5, where we raised the error of the award of attorney's fees, the trial court stopped the former husband short of testifying. So without all of the information necessary to appropriately weigh the financial positions of both parties, the trial court could not have, and it was an error in awarding attorney's fees. The supplemental petition did only contain that allegation that he was unemployed, but the supplemental petition was a viable document and could have been amended. And as we know, in the state of Florida, we have a fairly liberal amendment policy. So until that petition was resolved in some way or dismissed, as it ultimately was, it was still a viable petition. And the law is clear and settled that that petition, because it was previously filed, should have been heard either simultaneously with or before the motion for contempt. The trial court simply ignored that and moved along with the contempt. That was an error, and it requires reversal. We've already discussed the contempt. I mean, these are not the facts of an individual who should be assessed with a contempt finding. I mean, did he not pay? Yes, that is true. But it wasn't that he had the ability to pay and that he willfully didn't. If you look at his financial affidavit from September 2018, he did not have enough money to pay $2,000 a month. And as we all know, he was gainfully employed, but it's not as though we receive our annual salary right up front. I mean, he was getting that paid twice a month. So he didn't have a stockpile of money. It wasn't as though he received $70,000 or $69.96. I mean, that line of argument stops short and frankly is insufficient. And here again, it warrants reversal. These facts do not support contempt. The trial court erred in not making the proper findings, both as to contempt and as to the attorney's fees. The trial court did not afford him a meaningful opportunity to participate, including full testimony as to his financial position, cross-examine Ms. Jacques as to her financial position, and then make the appropriate arguments to defend against what ultimately was a finding of contempt and an imposition of attorney's fees. And then finally, The court should have heard the petition because it was a viable document. It should not have ignored it. It was previously filed. The law's clear, should have heard it either at the same time as the motion for contempt or heard it before, and the court just decided to ignore it. We raised 5 issues on appeal. All 5 warrant reversal, and that's what we're asking this court to please do. Thank you.
Thank you, Ms. Haverfield, and thank you, Ms. Jack. So thank you for participating to this oral argument remotely. So at this time, we're going to ask you to, we're going to take the next case. All right, very good. Thank you. All right, let's see, I've gotten